Evening, everyone. I'd like to welcome you to tonight's webinar entitled State of California Requirements, California Department of Cannabis Control, hosted by the City of Los Angeles's Department of Cannabis Regulation. My name is Frank Louie with the Cal Asian Chamber of Commerce, and I will be the moderator for tonight's event. Before we get started, let's take a moment to review some housekeeping rules. Please note that this webinar is being recorded and can be viewed after the editing process on DCR's website. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available to you during this session. However, you will be able to see and hear all of the panelists. There is an open chat box where you can interact with one another for networking or comment on the information. Please use caution when sharing personal information in the public forum and keep your questions focused on tonight's topic. Please ask questions. We encourage you to participate on tonight's subject matter in the Q&A box. We are gathering and responding to your questions throughout the presentation, and we'll have a Q&A session where we will get to those responses and questions in the last 15 minutes of tonight's event. You are encouraged to utilize the Q&A box at the bottom pane of your Zoom screen. If you use the Q&A box for questions, everyone will be able to see the questions when they are answered. Finally, please note that the content presented tonight was not created by the Department of Cannabis Regulation or the City of Los Angeles and is for informational purposes only. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code nor constitute legal advice. If you have specific questions outside of tonight's topic, please call 213-978-0738 during business hours between 10 and 4 to speak to a DCR representative. Now let's transition to the presentation for tonight. I'd like to introduce our speaker from the California Department of Cannabis Control, also known as DCC, Tamara Colson. I've had the pleasure of knowing and collaborating with Tamara since early 2017 as the state developed the regulations. Tamara Colson is the Deputy Director of the Legal Affairs Division for the California Department of Cannabis Control. Ms. Colson is responsible for leading a team which provides support services to DCC divisions with legal research, guidance, and representation. Ms. Colson came to the DCC from the Bureau of Cannabis Control, where in addition to serving as Assistant Chief Counsel, she took on the role of Acting Bureau Chief in 2020. During her distinguished career, she also served as Assistant General Counsel at the California Department of Consumer Affairs, Chief Prosecuting Counsel at the California Department of Alcoholic Beverage Control, and Administrative Law Judge at the California Office of Administrative Hearings. She has also served as a Special Assistant Inspector General and Deputy Attorney General. Ms. Colson began her legal career in the private practice and has subsequently spent over 20 years in the state service. Welcome, Tamara, and please begin your presentation. Thank you.
Thank you so much. I appreciate you all having me here today. I'm excited to talk about these topics with you. So as it was mentioned, I'm at the Department of Cannabis Control, which is the state licensing entity for cannabis businesses here in California. And today we're going to spend a little time talking about primarily some of our newer regulations, so that you can be familiar with some of the changes that have happened in the last several months. So I am going to share my screen with you. If you'll give me one moment here. Okay. Can you see that, everyone, I hope?
Yep, looks great.
Okay, great. Thank you. All right. So I want to talk a little bit about our what we call our consolidated regulations. For those of you who may be new to state regulation, regulations are simply the rules that about how you do things based on the statutory provisions. And so what we do is we go through a rulemaking process, and that is how these become applicable to all state licensees. For those of you who may know, prior to July of 2021, there were 3 separate licensing entities in California in the state government for cannabis. The California Department of Public Health handled the manufacturers, the California Department of Food and Agriculture handled cultivation, and the Bureau of Cannabis Control, where I started, we handled all of the other licenses. In 2021, we were merged into one brand new state department, a kind of one place for all cannabis licenses. And one of the things we have done is we worked towards streamlining and simplifying the regulations and incorporating reforms that support the legal cannabis market and better protect consumers. So what we did is we had emergency regulations in place initially, and then we went through the full rulemaking process, which hopefully some of you were able to participate in. And so we carried over some of those emergency regulations. We've also had made changes based on feedback. And the other thing that we have done is we had some additional regulation packages that set out some requirements for things like the large cultivation licenses, the equity fee relief program, and delivery information into track and trace. And so we will work our way through some of these today. So if you look at this slide, I wanted to share this with you. This is a screenshot of our website, cannabis.ca.gov. If you click cannabis laws and look at that drop down, I wanted to just show you so you knew where you could find this information. California cannabis laws will send you to a place that will give you links to the Medical and Adult Use Cannabis Regulation and Safety Act, which is the statutory provision in California that governs our cannabis businesses. And then, oops, sorry about that, wrong button. And then if you go down to DCC regulations, this will take you to a page and you'll see current regulations. If you click on that, that will show you all the current regulations that are in place right now. And so that's a really good resource. Rulemaking, if you click there, you're going to go to what we call our rulemaking page. And the rulemaking page will show you the regulations as they're going through the adoption process. And since it's early in the presentation, I'm going to make a plug now. Please, if you're in this business or plan to be in this business, or you are interested in the cannabis industry, please take the opportunity to participate in the process when we are making regulations and setting out these rules. We really appreciate your feedback and we consider it. And so if you go to that rulemaking page, what it will show you is we will propose regulations and it'll show you the text of what we're proposing of the actual rule, and then why we are doing it. So it will give you some insight into that. It will also inform you when the public comment periods are. So there are public comment periods where you can say, hey, we've seen this and here's our thoughts on it. We listen to that feedback and we often make changes to the regulations or the proposed regulations before they're put into place based on your feedback. So just wanted to highlight that's a great place, and we really, really do love your participation in those processes. Okay, so there were several changes in definitions in the regs in this recent round that went into place basically starting in late September last year through the first of the year, and wanted to highlight some of those for you. What I've tried to do in this presentation is highlight some of, I think are some of the more significant changes and some of the areas where we tend to get questions. This is not everything in the regs. This is not every change, but I think we've landed on some good highlights, hopefully. Mixed light cultivation. This was a change, and now it does not include light deprivation. For those of you who may be involved in cultivation, outdoor cultivation, this is an important provision. Previously, if you wanted to use light deprivation, tarps, anything of that nature, you had to get a mixed light license. That is no longer the case. As long as you're not using any artificial light and you are growing outdoors, you can obtain an outdoor license and do not have to get the mixed light. So if you have a mixed light and you are one of those people that fell into the outdoor but ended up in mixed light simply because you were using light deprivation techniques such as tarps, feel free to reach out to us about if you're interested in adjusting your license. Non-manufactured cannabis products. This has been amended to include both leaf, pre-roll filter tips, or paper. This was important because these non-manufactured cannabis products, that is something that you don't have to be a manufacturer to do. So making clear there what the different requirements were. Again, I've mentioned outdoor cultivation. It's also been addressed similar to the mixed light. We've added processing to include sifting activities. This was an area where there was a bit of uncertainty as to whether or not that was included. We have made some clarifications related to terpenes. So if you're a manufacturer, this is an important one. We've also made some changes to tincture in terms of the term vegetable. We've also put limits in on tincture sizes as well. And then another significant one is the definition of total THC has now been amended to incorporate Delta 8. Previously, it did not, and now going forward, it does. We've made several changes through these regulations for premises locations. Most of these changes were a result of questions we were getting and concerns from our licensees. So we have replaced the prohibition on licensed premises within private residence, simply scaling that back a little bit so that you would only be prohibited in your living areas of private residence. And that is because I know some of our licensees, and in particular, we've heard from some of the farming community that that this is problematic in terms of their local ordinances. So now you can use, say, your garage for cannabis activity in other areas that are not deemed living areas in your residence. And again, we've allowed it now to that to be reflected on your premises diagram, in part because that's a requirement for some of the local jurisdictions. And so we wanted to make sure that we were consistent there. Again, just a clarification that you can utilize your living areas for non-commercial cannabis activity, for example, your staff's breaks, or if they want to come in to use the restroom or something of that nature. Other significant changes to premises that have been areas where there's been some interest is this requirement for permanent structures. So we have removed the requirement that it must be permanently affixed to the land. So that gives you a little more flexibility. And this now does apply to all licensees. Previously, it only applied to those that were licensed by the Bureau. We did add a prohibition on personal cultivation occurring within the licensed premises. And again, this is just a clarification to make sure that your personal cannabis cultivation, if you're cultivating for yourself under the different laws that allow for that, and your commercial cannabis business. And then we have allowed a 6-month grace period as well to come into compliance with these provisions so that people can make whatever adjustments they need to. Storage of inventory, again, another area where we've made some changes. We removed the requirement that all inventory must be stored in a limited access area. So that gives you a little more flexibility as to how you want to structure your premises, and if you want, where you want to store your inventory and how much you want on the floor. We have required that bathrooms and changing facilities are separated from cannabis storage areas by solid walls from the floor to the ceiling. And that break rooms are separated from where cannabis and cannabis products are stored. Shipping containers, this has been an area where there's been a lot of interest and concern. So we are allowing the use of shipping containers as temporary storage. I know that we've heard that at different times of year, more storage is needed. So hopefully that will assist people during those times. This is obviously a very important one. This was done in a separate package from the consolidated, but it went into effect fairly recently. The Equity Fee Relief Program. Our Equity Fee Relief Program now has two types of relief. Last year it just had one. Now we have two. One is the fee waiver. And what the fee waiver is, it essentially waives your fee for licensing for that particular year if you're granted a fee waiver. Free deferral, and that is just what it sounds like. You still have to pay your fees, but you are given additional time to do that. So they're deferred to a later date. This is a program exclusively for equity licensees. And so we we've been working this program, at least the fee relief, for over a year now, and we've had granted quite a few. So I wanted to talk a little bit about the eligibility. You have to meet the equity criteria. The equity owners own 50% or more of the business, and your gross revenue or expected gross revenue. Some of you who may be applicants maybe don't know your actual revenues yet, of 5 million or less per year for that license. So if that's the case, the business will meet the requirements for fee relief and for ownership. And then we go into what's the equity criteria. And that has to do with offenses. So the cannabis offense, arrest or conviction before November 8th of 2016. Household income is less than or equal to 60% of your local jurisdiction's area median income, and you resided in an area disproportionately impacted by past criminal justice policies implementing cannabis prohibition for at least 5 years you were there. So if you meet all those criteria, your license may be eligible for a fee waiver. So we encourage you to take a look at that and see if that's something you qualify for and something that would be helpful for you. So many businesses have more than one license. And if you're in that situation, or if your revenues are over that 5 million and you still meet the other equity criteria, you can get a deferral through our deferral program. So, and this is really important because equity fee waivers are limited to one license. So you decide which license you'd like to apply for that for, and you can get that one. But additional licenses could be eligible for the deferral program. And what that would allow is either your initial license fees or your renewal license fees would be deferred for 6 months. So that gives you an extra 6 months to go ahead and pay those fees, but you're allowed to start operating, and we would issue your license. You can only get one per license per calendar year. Unlike fee waivers, you can get fee deferrals for multiple licenses. So again, if you're a business and you hold multiple licenses, you could seek deferrals for as many licenses as you choose, unlike the fee waivers. I wanted to show you a little bit about where you can find information on that program and on equity in general. Again, I've got a screenshot here of our website, cannabis.ca.gov. If you go to resources, you'll see where cannabis equity right there. I think it's the third one down, and it's in big bold letters. So you'd want to click on that, and that will take you to our web pages. There's also, if you go under applicants, apply for equity relief. And here's a website page where you can check to see if you're eligible for fee relief before you apply. It also has in these drop downs to these additional criteria for eligibility. And it allows you to check to see if you fall into those as well. So encourage you, if you think you are interested in the program, this is really a great resource for you to go to and check to see if you would qualify for that program. Okay, we've made some additional changes to premises operations, and this is where we have streamlined modification processes. Previously, more processes required department approval. We have scaled that back, and there are now a number of modifications you can make to your business, and we don't need you to get prior department approval. You would just need to notify us. And so that section hopefully allows people a little more flexibility in terms of making changes to their business, and those that don't require our approval. Some of them still do things like changes in ownership and some of those, but do check that out as you're making decisions about your business, and you may be able to make a change and not have to get prior approval from us. The next thing is conversion to large and medium cultivation licenses. For those of you that have been around for a while, this has been something that's been on the horizon for a very long time. The statute did not allow us to issue the largest cultivation licenses that are allowed. we had to wait until January of 2023. So we are now issuing large cultivation licenses. These would be ones that are over 22,000 square feet if you're indoor or mixed light, and 1 acre if you're outdoor. So because, and previously our regs only allowed you to have 1 medium license. And so though that has changed as well. So what we've done is there is a process we're allowing in our regs that if you have a number of licenses, smaller size licenses, and you want to group them and make them 1 medium license or 1 large license, you can do that. And if you meet certain criteria, you're not going to have to start with a new application to get that done. So what you can do is smaller. It can go into either a large or a medium. The licenses that are going to be part of that new larger size premise would need to be contiguous. This is for cultivation. They have to be held by the same licensee, and at least one of those licenses must be active that's within the proposed premises. If you are looking to change to a large license, please note that in order to do that, all licenses must be eligible for annual licensure, and you must be complying with the restrictions of holding an interest in a testing lab, distribution, or micro business. So if you have a large license, if you want a large license, you cannot have interest in those other types of business, and you must be eligible for annual licensure. The department is not allowed to issue provisional licenses that are 2,200 square feet, over 2,200 square feet, or over 1 acre that are contiguous any longer. So you would need to do that. We can for your, so we can convert smaller sizes into medium provisionals if you already have a provisional, but we cannot do the large. So that's an important thing to keep in mind as you're looking at your business options. Advertising is another area where you'll see some changes, and some of these provisions have been made to apply to all licensees, whereas previously they applied to a subset. And that is that you cannot market and advertise cannabis goods that are labeled with terms used to describe alcohol. It does not prohibit the use of a company name or brand name that is also associated with alcohol, provided the cannabis goods meet the requirements of the section. We've also clarified that you cannot give away any amount of cannabis or cannabis products or any cannabis accessory. As you may know in the statute, there are some prohibitions against free cannabis and cannabis goods, and also have clarified that you cannot hold raffles or sweepstakes as part of your business promotion. There are legal rules related to being able to do any sort of raffles or sweepstakes in California. And so that is to make sure you're in compliance with those. And we removed a grace period for branded merchandise that was no longer valid. Okay, trade samples. This is another area where we now have regulations and statutory authority to allow for trade samples. These are samples that licensees give to each other in order to get them interested in your products and maybe to buy your products or to stock your products. So this is allowed. It is not allowed to give trade samples to consumers. So keep that in mind. And some of the changes are that we now allow nurseries to provide trade samples in the way of immature plant seeds and propagated material. We also have made a change, which I think is a really great one, and hopefully other people will, to originally trade samples had to be destroyed if you did not use them. So if you had a bunch of trade samples and you plan to give them to other licensees and you didn't, you couldn't sell them to consumers, you couldn't give them to consumers, and so they would just go to waste. And once something's designated as a trade sample, you can't change that. So that was another issue. They have to be packaged a certain way and as trade samples. But due to some wonderful feedback that we got during the regulatory process and that rulemaking process, we decided to go ahead and make a change, and this is that trade samples can be changed from trade samples to medicinal donations. So if you've designated something as a trade sample and you want to allow it to go to medical donation because you're not going to use it as a trade sample, you can go ahead and do that. And hopefully that will increase access for our medical patients. And then we have clarified the requirements for when you can provide trade samples to your own employees and the different requirements for that. Storage services, for those of you who are involved in distribution, this is a big one, I think, that we have heard a lot about over the years. And so we have made a change. So nowadays, if you are storing product at a distributor's premises, not yours, another distributor, and it's storage only, what you can do is, instead of those products having to come from storage back to your own premises and then go out to retailers, they can be distributed directly from the storage site. So you can have that distributor, or you can pick it up, if you do distribution, your own license, and you can say, for example, if you're storing it in LA, you can then have it distributed straight from there to the LA area so that it doesn't have to come back up north if that's where your licensed prem is, and then go back down. So hopefully that will result in fewer trips for the environment, and actually also allow you a little more flexibility in your businesses. We've also made some changes for the transportation of cannabis and cannabis products. We've clarified that you do not have to be, the business does not have to be the sole owner of a vehicle that's being used, and owners may use that vehicle also for non-commercial purposes. And we've clarified the motor carrier permit. If you need one of those, that does need to be issued to the licensed distributor to have that part of your business. And then we've also made a little less cumbersome the setup of your delivery vehicles and your transport vehicles. We've done this both for delivery from retail and transportation from distribution. And that is that we know we used to require you not to be able to use all the sides of the vehicles as part of the enclosed area where you had to secure your cannabis and cannabis products. We have changed that. So now you can use the sides of the vehicle for 3 of the sides. So you only have to have one kind of gate or locking area instead of an entire cage, as I think how people were referring to them up until now. Curbside delivery. During the pandemic, we had several businesses that were engaging in curbside delivery under disaster relief, in part because of the rules by their local jurisdictions of the state about people coming into the premises. After doing that, we decided to go ahead and make that a permanent part of our regulations. So you no longer need disaster relief to engage in curbside delivery. We have several requirements which were similar to those under disaster relief in terms of checking IDs and surveillance and whatnot. Just wanted to make sure you were aware of that. Sale of non-cannabis goods. Previously, we were not allowing retailers the sale of anything but cannabis, cannabis accessories, and branded merchandise. There's been a lot of interest in the ability to carry other items. And so we have now allowed retailers that have a consumption area to sell pre-packaged non-cannabis infused and non-alcoholic food and beverages if allowed by your local jurisdiction. So if your local jurisdiction allows you to have a consumption lounge on your premises and they would allow you to sell this food, you would be able to do that now under the state rules. We've also clarified that if you have a consumption lounge, that you are not prohibited from having food come from, let's say, your patrons want to use DoorDash or something of that nature, that they can do that and eat it there. Okay, medicinal donations. We have added some additional requirements for providing free cannabis goods to medicinal consumers. If you are doing that, really want to make sure you take a look at this, because it does require some verifications with licensing boards for medical personnel and some specific record keeping requirements. these requirements are in the regs, but they mirror what the legislature put into place for terms of the verification process. And then delivery employee, oops, I'm sorry, I went back. Okay. So delivery, we allow for receipt of cannabis goods only during hours of operation. And we no longer require the delivery employee to return to the premises all the time. It's only now if at the end of their delivery time, they still have product, they have to take it back to the premises, but otherwise they can go home and don't have to make that trip to the premises, at least not based on our regulations. If you as an employer want them to do that, then that is something you can decide, but the state no longer requires that. Okay, again, this delivery vehicle requirements, this is that same one related to using the sides of the vehicle. It's just for delivery. We've made a significant change to the way cannabis can be carried during delivery. We've increased the value of goods that can be carried in the vehicle to $10,000. Yes, $10,000. And we removed the limit on how much you can carry that has not yet been ordered. So you can go ahead and not have to do that split in terms of what you have in the vehicle that has not already been ordered and paid for, and what you have in the vehicle that has been. Now you can, you just have to comply with that $10,000. Creation of the delivery ledger in CCTT, which is, California Cannabis Track and Trace System. We also call it Track and Trace. The company we use is Metric, so those all mean the same if you're hearing those terms kind of interchangeably. Right now, you are allowed to do your delivery ledgers outside of the system. Starting April 1st, the requirements to do it within the system go into effect. Some of you may already be doing it if you're already operating because the functionality is there, but we allowed people a transitional time before they had to start using it, since these requirements came into being at the end of December, and that was based on some legislation that was passed this past summer requiring that. One other thing too with the delivery ledger is that you must update it after each delivery. So when you're out in the field, if you are doing it in Track and Trace and you have that electronically with you, you can, after each delivery, go into Track and Trace and log it, and that is perfectly fine, but it's not required. So if you're not using that, you have to update your delivery ledger after each delivery, whether that's you have an electronic system or you have a paper delivery manifest that you handwrite that in. And then by the end of that calendar day, it all needs to be entered into the system. Okay, participation in cannabis events. Again, an area there's been a lot of discussion about and interest in. So we have added some clarity in regards to participating in temporary cannabis events by non-retail licensees. We have now allowed those of you who are not retail licensees to be able to display some of your products. You cannot sell them, but you can display them. And we've provided limits to that. If you are just displaying cannabis, you can bring it yourself without using a distributor, provided you are under the personal possession limits for the adults that are participating. You're allowed to display accessories, packaging materials, promotional materials, branded merchandise. You can sell your branded merchandise and accessories in compliance with state and local laws, but you cannot sell directly to consumers, nor can you be selling in the retail area. Retailers are still able to sell their cannabis at an event like they have done before in the retail area. Oh. Questions? I think we've hit the end of my prepared slides.
Well, that's a lot of information, Tamara. but good information. So, I mean, lots of updates, always update. There's always changes and updates, and and maybe a little bit here we can kind of review some of the the guidance on where to go to stay in up to speed on those. Several questions. So I had a clarification question, first of all, on, you mentioned the fee deferrals for up to 6 months. Is there a deadline to request that? I mean, is that offer available for the calendar year of 2023? Or I mean, what's the
Yeah.
length of, yeah.
So it's available annually. It's just started in 2023. Typically you would want to do that, as part of and before your as you're renewing as part of that process, because it would be deferred. There may be some people though, because the fee deferrals just went into effect at the beginning of this year. Maybe you're kind of mid-renewal cycle or whatnot. And if you are, I would encourage you just to go ahead and reach out to, our folks about your particular situation, and they can help you. But typically it's to go hand in hand. It would be as part of the renewal that would be applied. So you want to get that in either before or simultaneously.
Okay, great. Let's go to some of the audience questions. Let's see here. Svatslav, where can I find the rules and regulations for creating the premises diagram? You had mentioned, referred to premises diagram in one of your earlier slides. Is there?
Sure. Yeah. So the premises diagram is something that you would submit. In our regulations, it's section 15006. So if you go to our regulations, how I showed you, you could do that in the earlier slides. Pull up the current regulations and look for 15006. That talks about what you need to have in there. The other place you can go to is there is a premises diagram. There's like a form that can help you. And that is in our resources section.
Okay. So basically navigate, through the website, you can navigate and find all that information, right?
Yes.
Okay, great. And then here's a question from Jenny, and I know it was regarding waivers and deferrals, but maybe I can build on this. Will you address application fees for SEIA with waivers and deferrals? I mean, obviously, social equity individual applicants are eligible for waivers and deferrals. Maybe the question from Jenny is, what's the value of those waivers? I mean, what are the typical fees, and if they're getting waived and deferred?
Yeah, so the waiver would be based on what your fee is. So if you are applying, if you're applying for an application for a certain type of license and you figure out where you fall, our licenses for cultivation are based on square footage. For everywhere else, it's on anticipated revenue or gross revenues. And you would figure out what category you fall into, and then the fee waiver would be for the amount of your license fee.
Okay, so it's going to be variable, but once calculated, it's not like there's a cap or anything. It's like if it's calculated at X, it's eligible, right?
Yeah, as long as you meet all the other requirements. The only thing to keep in mind is that if we run out of money, the amount that the legislature has given us, you may not be able to get a waiver if the funding is gone. But always, if you think you're eligible, go ahead and ask. And, for some reason we can't grant it, because we'll let you know. But yeah, so that would be the one thing to keep in mind.
I know that's interesting.
What we've been budgeted.
Yeah. No, and I guess that makes sense. So, it's not an unlimited pot of money. There's certain dollars that have been allocated and approved by the legislature. Is there I have no idea how how significant and how much has been accessed, but I mean, is there a sense of urgency around that? I mean, obviously, first come, first serve, but is there a
Yeah.
sense of urgency? Like, I mean, I don't know if you can answer that directly, but I think we're early on, so it's probably a reasonable runway here, right?
So we do track that. I do not have those numbers right now. I know
Mhm.
we've granted quite a few. I know, as far as I know, we haven't made any announcements that they're
Mhm.
no longer available. So from that perspective, I would go ahead and if you think you're eligible and you're interested, I would recommend that you reach out or submit your
Mhm.
application.
Yeah. Yeah, that'd be great. And I don't know how, and if the state will be able to kind of, put out some notices or communications on that ongoing. It'd probably be valuable and helpful because, as you know, there's hundreds of thousands of social equity individuals out there in California, right? So,
Yes.
but hopefully we're still early in the process and there's lots of funds available, right? Let's see, another question from Sviatoslav, and this is around your delivery employees, the timing. Can a delivery employee take orders that came in? I remember you said 10 p.m. as the cutoff, but if a delivery order comes in, i.e., he used an example like 9:55, is that a eligible transaction? You can still deliver that?
So you need to complete your deliveries by the end of the delivery hours. So
Okay,
if you can deliver in 5 minutes, sure.
okay.
Right. So the idea is that, deliveries stop at a certain time. Previously, though, just to give you some perspective, it used to be that your delivery employees had to be back at the premises by that time. Now
Ah,
they just have to complete their delivery activities. So you do not have to calculate in a return time to the premises in time to make that cutoff. So that's for the state rule. Again, like with all of these things, your locals may have something different. So if the local jurisdiction only allows you to deliver, say, till 9, then you would have to comply with that. But even if the local would per se allow you to go beyond 10, which I don't think any of them do, I think they line up with us, you would still have to comply with the state rule. So definitely check with your local jurisdiction with LA. I assume you're with LA to
yeah,
see, if they have anything specific that would impact that for you.
yeah. No, but that's helpful because I do remember, or you had to be back at the premises. So this does give you more,
Yes.
sale and delivery time, but still the deadlines are completed transaction by the hour, not let's take orders up until 9:59 and spend another hour delivering, right? Yeah. So that's
Correct.
good clarification. Yeah.
Yeah. And we've also changed it too, where if your delivery employee finishes and has no more products in their vehicle, they can just go home. They don't have to travel back to
Yeah.
the licensed premises. And depending on how far they are from your licensed premises, that could be a, significant time savings and potentially some gas savings too.
Yeah. And just clarify, which I think is a really important point around the dollar amounts eligible, because that increased quite a bit and should be another efficiency productivity, right, benefit.
I would think so. It does allow for you to, and that was one of the comments that we heard from
Mhm.
people about this, the prior rule and what they wanted to see in our changed rules in the rulemaking process was that it would be more efficient because that way you can send someone and they don't have to come back and forth as much. Also, same thing about those pre-orders requiring that a certain amount be pre-ordered before, you can't go over a certain amount. And so I think that will give more flexibility as well, more
Yeah,
efficiency.
great. Yep, and another question from Sviatoslav, which is a pretty interesting question. When will delivery personnel have the option to deliver on a motorcycle with an enclosed trunk if they choose to use something other than a car?
That is a very good question. I can't say that I know when we might be heading in that direction. Right now, we don't necessarily come out and say this is the vehicle you have to use, but any vehicle has to meet our requirements. But like anything, our requirements for the vehicle have changed since we first put them out. And you used to know you couldn't use the sides of the vehicle to make the enclosed area. You had to basically get a cage or a box or something within the vehicle. And now you can use 3 sides of the vehicle. So that is definitely a little more flexible than what the regulations were early on. And as always, we are looking for feedback and information as to how you think we might be able to improve them. So feel free to share that with us, and I'll jot that down as well.
Yeah, yeah. Yeah, it reminds me of a lot of the other industries where, I think of San Francisco at downtown LA where everyone's on bikes and motorcycles and all that, right? So probably
Yes.
some as things evolve, right?
Correct.
Daryl had a question. If a person has an event, and I think he was referring to maybe not even necessarily a cannabis event, can people with licenses sell their cannabis at the event like a vendor at a vendor booth?
So, if you are participating in a licensed temporary cannabis event, retailers can sell, or people who are authorized to engage in retail, such as a micro business, at those cannabis events. You cannot sell cannabis at a event that is not a licensed temporary cannabis event.
Right. Okay. Yep. So it has to be a licensed cannabis event, period. Right.
Correct.
Not
If you're going to be selling cannabis, yes.
yep. Yep. Not the local, night market. Right.
Correct.
Right. Good.
Correct.
Good clarification. Tiana has a question. Is there a deferral, or maybe you answered this earlier, maybe, is there a deferral or fee waiver for the state application fees, or they're only available on license fees?
So you can definitely apply for waivers, and so typically they would be they're typically for your license fees. If you want to look at specifically what fee you want, I'd recommend you go to that. But yeah, so we're going to go ahead and allow you to request either a deferral or a refund. I'm sorry, let me start over here. I got a little confused, little turned around. So there's both the fee waiver and the deferral. The waiver, you can have one, and then if you want a deferral for other licenses, you can also apply for that. I'm not sure if does that answer your question?
Yeah, Tiana can, if she wants to add or build on that, it may have answered. I know you can get one fee waiver, and then deferrals, you're not limited to one. You can do multiples, right?
Correct.
Yeah. So I think I understand that. Let's see here. Kachik had a question around getting more information on consumption lounge applications. I don't know if there's reference on this DCC site around consumption lounge information on applications, or maybe specific regulations.
So whether or not you can have a consumption lounge is up to the local jurisdiction. When we issue and that would be for a retail license, a storefront. So, or potentially a micro business that's engaging in storefront retail. We would issue the state license. Whether or not you can engage in consumption activities is a function of the local jurisdiction. So the state license, and the state's position is basically, in the way the statute is, you can have a consumption lounge provided your local jurisdiction allows you to. The state does not say you're allowed to have a consumption lounge or you're not allowed to have a consumption lounge. That ability to have one rests with your local jurisdiction.
Great. Okay. Let's see, a couple other questions have come in. Is the department still accepting applications for provisional licenses?
Very good question and a very timely question. So as you know, you probably know our department's ability to issue provisional licenses, and those are the licenses that allow you to begin operations while your local compliance is underway or your CEQA compliance is underway, provided your local jurisdiction will allow you to operate while you're still compliance underway with them, has been limited. So where we're at right now is that we can only issue provisional licenses to equity applicants right now. And this is the last batch. Everybody else's timelines have gone away, but equity applicants still have a little bit more time. But there's a really important deadline that's days away, and that is, in order to be considered for a provisional license, you have to have your application into us. The technical deadline is March 31st. However, that is a state government holiday. It's Cesar Chavez Day. So because of that, we have to accept them the next business day, as if it were that day. And that next business day is Monday, April 3rd. If you're on our listserv and all of that, I believe there was some information that was sent out. So you need to get everything in no later than that. And then we have up until the end of June to issue provisional licenses, and we're going to get through as many of them as we can. So if you're interested in a provisional license, you really have to act, and you have not already put in your application, you'll need to act fairly quickly. The deadlines are statutory, that we lose our ability to issue licenses at a certain time at the end of the fiscal year. So thank you for that question. I think it's a really important question for this week, because we are days away from the ability to issue provisional licenses, no longer being something that the department can do absent further legislation.
Great, that's it. That's very helpful to clarify and re-clarify. And maybe a follow-on question: can you renew a provisional license? So assuming you already have one, right?
Yes, you can. The department can renew provisional licenses. As you know, they're annual, not an annual license, but the provisional licenses are good for 1 year. So it's an annual provisional license. It gets a little confusing because we have those different, but they can only be valid for 12 months. So every 12 months you would have to renew, but there are some restrictions that are coming up. The last date the department can renew a provisional license is in 2025, which is 2 years away. It doesn't sound like that close, but it is. But the one thing to really keep in mind is with each renewal of a provisional license, there are additional requirements. And these requirements are geared at making sure that you are making progress on your CEQA compliance, making sure you're making progress on getting to annual licensure. So there are requirements if you're a cultivator for what you need from Fish and Wildlife and what you need from water boards. I encourage you to look at those, because the beginning of each fiscal year, which is July 1 of every year. So we're coming up on July 1, 2023. And so the renewal requirements will be a little different than what they are right now. And then the following year, they'll be a little different. And each one, it requires you to be a little further along in the process. So please take a look at that. It's not like it's been for some of you who've had provisional licenses for a long time, where we issue you the provisional license and then you just pretty much get one every year, unless the local jurisdiction says they're not going to allow that. So do take the time to take a look at those. I think they're important. They're in our regulations, and they're also in the statute. And in the statute, they are at Business and Professions Code section 26050.2. And then also in our regs, you can find the provisions that relate to that as well. They pretty much mirror the provisions that you're going to see in the statute.
Great. Great. Let's take a couple more of these questions that have come in. Are there resources to assist applicants with the application process?
Yes. So those of you who might be needing to get your application done and quickly, let me tell you where you can find some great resources. So if you go to our website, and when you go onto our website, you'll see some tabs at the top there, and there's one that says applicants. So click on applicants, and then in that drop down for applicants, you will see something that says it'll say resources, and it will take you to our resources page. And this is really helpful. You're going to find what I think is a great tool for you, and it is our application checklist. And what that does is it's a checklist, and you can read down it, and it's going to show you all the things that you need to be providing. And this way it'll help you kind of go through it. I think it's a really valuable checklist there. As I mentioned, there's also the premises diagram form. There's other forms as well that you can use that can be helpful. The other thing that's really, really helpful too is there are also instructions for how to navigate through our online system when you are putting in your application. Please make sure you follow the rules for the type of application you're applying for. And the reason I say this is keep in mind that at one point we were all different programs. And
Yes.
so some of the technology is still catching up. So, but really, I encourage anyone, if you're an applicant, go to that area. It's really, I think it's very helpful.
Yeah, that's great. That's great advice, and thank you for sharing. I mean, I know that sometimes complex and intimidating, but I think the website's much more user-friendly, and people can get familiar and just find their way through there. They can get a lot of these questions answered.
The other thing we have too on our website is, and I think it's easiest to find this if you go to the tab for licensees. That's the easiest way to get to it. But it's our Canna Connect Canna Hub, and it has all kinds of resources to assist you with compliance, different things of that nature, guidance documents. So that's also really a helpful website. It's more geared to compliance once you're licensed than the one I previously mentioned, where you go to applicant and then you go down to the resources page specific to applications.
Great. Yeah, and I see that the team is putting some of those links in the chat, so please reference those if you have anything specifically. And then just kind of couple up to wrap up, and maybe this is very appropriate given what's happening in California, but just around what can licensees do around impacts to disasters? We got flood, we got rain, we got fires, we have everything in California, right?
Yeah. And up until February, we had COVID considered an emergency as well. So the department does have a disaster relief program, and what it's targeted for is if you are impacted by a disaster, you can request relief from certain provisions that will help you, navigate that disaster and its impacts. And that is found in our regulations at section 15038. There's also a piece on disaster relief on our website that you can take a look at. And basically, if there is a disaster and there's been a declared state of emergency, you can say, hey, we can't comply with this particular provision, and here is why. And then we work with you to figure out, if we can allow you to say, get relief and not have to comply with something for a finite period of time to allow you to weather the disaster. So there's information on our website about what you need to provide us with. It's typically what's going on, what do you need, why. But there's some guidance there, and there's also an email called disasterrelief@cannabis.ca.gov specifically for disaster relief requests.
Great. Well, hopefully those disasters are behind us, but we'll see as we look forward to spring and summer, right? But
Yeah.
and then you know, one more clarifying question. And I know during the pandemic, you know, there was curbside delivery. But you know, this question is really, you know, maybe you can answer it a little bit more broadly, but can non-storefront delivery licenses engage in curbside delivery?
They cannot. They
cannot.
can only deliver. So the curbside, if you have a storefront, you can go out to a vehicle that's parked immediately in front of your premises to deliver that. If you are a non-storefront, which means you are, engaging in sales just by delivery, you don't necessarily have a public premise, you have to continue to do your cannabis sales via delivery and aren't eligible for curbside.
Great. Well, Tamara, the time has flown by as always, right? So
yes,
a lot of great content, a lot of great information, a lot of great clarifications on the questions. Let's go ahead and wrap up. I mean, we appreciate and thank you everyone for attending this informative webinar offered by the City of Los Angeles Department of Cannabis Regulation. Big thank you again to Tamara Colson for supporting the City of LA DCR and the program. We value your participation and involvement, and it's very helpful. This webinar recording will be found on DCR's website at cannabis.lacity.org. If you have any additional questions about accessing your account, please email dcr.sep@lacity.org. Also, if you have any other additional questions around the content for tonight, please reach out to the Department of Cannabis Regulation, as we referenced earlier, around the phone number and the email that we referenced. Thank you all for joining us. Have a wonderful evening, and we look forward to seeing you at future and upcoming webinars here in the near future. Thank you all, and have a good evening. Bye-bye.